And from that interview, let's move on now to the views of two senior lawyers on the propriety of nominating for public office persons who are being investigated for allegations of corruption. Ideally, should such persons even be considered?
Now, for me, for nominees for appointments generally, whether ministerial, board appointments, chairmanship of boards or whatever, I think that for my own opinion will be that whether or not you have a case against you pending in court, the president should be able to nominate you. Why do I say so? In Nigeria, we practice the adversarial criminal system, in which you are presumed innocent until otherwise proven in a law court by a court of competent jurisdiction. So it will be counterproductive, for instance, for you to say that because somebody has been charged to court in a criminal matter, then that person should not be nominated. But having said that, because of the high moral ground that the president has come into office with, claiming that he's fighting corruption, ordinarily, I would think that the president should not be nominating people who have corruption charges against them. Because, I mean, if you're fighting corruption, you should be seen, and your nominees should also be seen to be above board as Caesar's wife. And if a government claims to be fighting corruption, ordinarily, shouldn't be nominating people who have corruption charges. That's what I'm saying.
When you look at the Constitution, until a man is taken through the mills of the law, convicted, he is presumed to be innocent. So if we rely on that plank, you might want to say that it will be wrong for Mr. President or for not to nominate anybody who has a case in court as a minister, and that it also be wrong for the Senate to deny somebody a ministerial appointment simply because he has a case in court. If it is that way, the question will be that we want to look at it now from the moral perspective. Is it justifiable for people who are accused of very, very serious infractions like investment of public funds and all that to also be nominated as minister? I would want to say with all emphasis at my disposal that it is inappropriate, simply because we will not only be sending the wrong signal, not just to Nigeria, but to the whole world, that anything goes in this country. In some other climes and other peer review mechanism is even more important, that once a man is accused of something that is inappropriate, like places like the US, in Britain, and what have you, or Canada, they themselves voluntarily would decline to come forward to accept any public offices and all that, because they think they haven't lived up to expectation. So that is my feeling. The way we can really solve that problems might be because, look at Section 147, which talks about that the president will just nominate anybody he deems fit as ministers. It only prescribes that there should be at least one minister from each of the states of the Federation. And Section 148 of the Constitution goes ahead to say, look, the appointment of portfolio, the responsibility that the president gives to these people is going to be at his own discretion. If we are going to find solutions to some of the things we've been seeing, and especially with the issues that Dina has raised, the way to go about will say, look, once a person is nominated as minister, apart from the security people, the DSS, and the police writing security reports, we could also say, in addition to that, the Senate could advertise the names of such persons who have been appointed as ministers and ask the members of the public who have objections to write to the Senate, so that whatever objections are taken from the public will be considered alongside with the security reports that are coming from the DSA. The Senate could also go ahead to say, look, the EFCC, the ICPC should also write reports on people who have been nominated as ministers by Mr. President. If you begin to get reports from all these different sources and all, I am sure if the report coming is not complimentary, the chances are that people who have been nominated for such offices themselves will feel too ashamed to come forward and to be screened for such ministerial appointment.
And on the home stretch, let's bring you a recap of some of the top stories we tracked at the core.
We begin with the report that the Presidential Election Petitions Tribunal has reserved judgment in the petition filed by the Hope Democratic Party, the HDP. The tribunal reserved judgment in the petition on Monday, 5th of August, after parties in the petition had adopted their final written addresses. The HDP is challenging the victory of President Muhammadu Buhari in the February 23rd elections. In its final address, the party asked the tribunal to set aside the presidential elections on the grounds that the Independent National Electoral Commission did not follow conditions in the Electoral Act before postponing the poll earlier scheduled for February the 16th. The party also said that because INEC did not follow the conditions before postponing the election unconstitutionally, a referendum was conducted in line with the law, and the presidential candidate of the HDP, Mr. Ambrose Owuru, emerged winner of the referendum with over 50 million votes. The party therefore wants the tribunal to nullify the declaration of President Muhammadu Buhari by INEC as president and in his place restore Mr. Owuru as the authentic winner. The president and his party, the All Progressives Congress APC, has however urged the tribunal to dismiss the petition on the grounds that it's frivolous, baseless and lacking in merit. Still in Abuja, the Federal High Court on Wednesday, 7th of August, ordered both the Senate and the House of Representatives to halt their plan to take over the legislative duties of the Edo State House of Assembly. Justice Taiwo made the order at the resumed hearing in the case instituted by the Edo State government to challenge the directive by the chambers of the National Assembly to the governor of the state, Mr. Godwin El-Zakzaky, to issue a fresh proclamation of the state's House of Assembly. The National Assembly threatened to take over the legislative duties and powers of the Edo State House of Assembly should the governor fail to make the fresh proclamation within a stipulated time. But Justice Taiwo ordered parties in the case to maintain status quo pending the determination of the case. The same Justice Taiwo on Thursday, the 8th of August, granted the Department of State Services permission to detain the publisher of Sahara Reporters and convener of Revolution Now protests, Omoyele Sowore, for 45 days. The judge was ruling on an ex-parte application by the security agencies to detain Sowore for 90 days in order to investigate him for treason-related allegations. According to the judge, the 45 days period starting from Thursday lapses on September the 21st, the date for the next hearing of the case. And in Kaduna State, Justice Darius Kobo of the State High Court on Monday, August the 5th, granted the leader of the Islamic movement in Nigeria, Ibrahim El-Zakzaky, leave to travel abroad for medical attention. Justice Kobo said El-Zakzaky could travel in the company of the Kaduna State government officials. The judge also said that the IMN leader must return immediately after his discharge from the hospital to face his charges. El-Zakzaky, his wife and 2 others allegedly murdered a soldier who was said to be in the convoy of the Chief of Army Staff, Lieutenant General Tukur Buratai, during the December 2015 bloody clash between the Shiites and the soldiers in the convoy in Zaria, Kaduna. And we round off at the Federal High Court, Lagos, with the report that Justice Chuka Obiozo on Friday, August 9th, granted bail to Professor Maurice Iwu, a former chairman of the Independent National Electoral Commission. Professor Iwu got bail in the sum of 1 billion naira with 2 sureties in like sum. A day before he was granted bail, the EFCC arraigned the former INEC chairman before Justice Obiozo on a 4-count charge of concealment, fraud, and money laundering of 1.2 billion naira. The money is believed to be part of the 23.29 billion naira slush fund allegedly shared by former Petroleum Minister Dezani Alison Madueke to influence the outcome of the 2015 presidential elections. If convicted, the former INEC chairman faces a prison term of not less than 7 years and not more than 14 years in accordance with Section 15, Subsection 3 of the Money Laundering Prohibition Act 2011.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeats on air or watch via our YouTube channel. I'm Shola Shieli. See you next week.